just a few more moments to make sure we have everyone entered from our waiting room here. So just hold for a few more seconds and then we'll get started. Thank you. All right, good morning. It looks to me like everyone has had a chance to enter from our waiting room. So I'm going to go ahead and get started. I am Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference for the pending application of the County of San Joaquin, application 29657, for a permit to appropriate water from the South Fork American River by diversion at the Freeport Regional Water Authority facility located on the Sacramento River. This pre-hearing conference is being held in accordance with the Notice of Public Hearing and Pre-Hearing Conference dated June 10th, 2021. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site so that all of you can access that. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you are experiencing technical difficulties trying to communicate with us, please send an email during this pre-hearing conference to the AHO at admin@hrgoffice@waterboards.ca.gov. Our staff will be monitoring that email inbox, and so we can try to work out whatever technical difficulties we may have. Assisting me today are several staff of the Administrative Hearings Office: Nicole Mullen, Amy Blunk, Megan Nyes, Skylar Anderson, and Kyle Wooldridge. I think we'll start by moving to appearances. This looks to me like it might be the hardest part of our morning, so we'll try to move through it quickly. To do that, I will identify each of the entities that filed NOIs for the hearing. And as I do, if you are representing that entity today, please unmute your microphone and state your name. But as we proceed, if you can please keep your microphone muted except when you are speaking, that would be helpful to reduce background noise. So we'll start with San Joaquin County.
Barbara Brenner, outside counsel on behalf of San Joaquin County, the applicant.
Thank you very much. Good morning, Ms. Brenner.
Good morning.
The City of Stockton.
Yes, Mel Lytle, representing City of Stockton.
Good morning, Mr. Lytle. North San Joaquin Water Conservation District. I have in my notes Ms. Spalletta is, I don't see Ms. Spalletta in our role here at the moment, so I will circle back. Let's move on to the State Water Contractors and Kern County Water Agency.
Kira Johnson on behalf of State Water Contractors and Kern County Water Agency. Joe Burns should be joining us around 9:10 this morning.
Great, thank you, Ms. Johnson. Westlands Water District. Mr. Rubin from Westlands Water District, do I have you on the line? And if I don't yet, I will also circle back. I realize we came out of the gate running this morning, so. Contra Costa Water District.
Doug Cody, appearing for Contra Costa Water District.
Thank you very much. And I note in your NOI, you identified yourself and Mr. Matto as providing policy statements only. So is that correct?
Correct.
Do I understand?
That is correct.
San Luis and Delta Mendota Water Authority.
Yes, this is Rebecca Aykroyd for San Luis and Delta Mendota Water Authority, and Carissa Beecham is also appearing for the authority.
Thank you. Thank you,
Good
Ms.
morning.
Aker. Good morning. Glen Calusa Irrigation District.
Yeah, good morning. Andrew Hitchings for Glen Calusa Irrigation District. I also wanted to note that I need to, if the hearing is not over by 10:10 a.m., I am going to have to step off, but Aaron Ferguson, my colleague, will also be appearing for GCID at that time if necessary.
Thank you, Mr. Hitchings. I think we have a good chance of being done by then, but thank you for letting me know.
Yeah, thank you.
Sacramento County Water Agency, which I believe would be Mr. Ferguson.
Yeah, good morning. Aaron Ferguson, Sacramento County Water Agency.
Good morning, Mr. Ferguson. El Dorado Water Agency.
Good morning, Ms. Kinsey. Kevin O'Brien for El Dorado Water Agency.
Good morning, Mr. O'Brien. El Dorado Irrigation District.
Good morning, Brian Polson on behalf of El Dorado Irrigation District.
Thank you. Good morning, Mr. Paulson. Freeport Regional Water Authority.
Janice Snyder appearing for Freewa.
Good morning, Ms. Snyder.
Good morning.
Thank you.
Good morning.
San Juan Water District. I have in my notes Mr. Helliker. I will circle back to see if he joins us later. The City of Folsom. City of
Mr.
Rose.
Walker is actually on vacation this week.
Oh, I'm sorry. Thank you very much for letting me know. I have his NOI, so we have that in our record. City of Folsom, City of Roseville, Sacramento Suburban Water District, Woodland Davis Clean Water Agency.
Jennifer Buckman of Barkowitz, Chronic, and Shanahan appearing for those parties.
Thank you, Ms. Buckman. Placer County Water Agency.
Good morning, Dan Kelly, counsel for PCWA.
Thank you. Good morning, Mr. Kelly. City of Sacramento.
Good morning. Christopher Strauss appearing on behalf of the City of Sacramento.
Good morning, Mr. Strauss. California Sport Fishing Protection Alliance.
Good morning, Chris Schutz, appearing for California Sport Fishing Protection Alliance.
Thank you. Good morning, Mr. Schutz. Friends of the River.
Ronald Stork, Friends of the River Conservation Staff.
Thank you. Good morning, Mr. Stork. The United States Bureau of Reclamation.
Lisa Holm appearing for United States Bureau of Reclamation.
Thank you. Good morning, Ms. Holm. California Department of Fish and Wildlife.
Jessica Schroeder appearing for the Department of Fish and Wildlife.
Thank you. Good morning, Ms. Schroeder. And I have noted from my staff that Mr. Rubin with Westlands Water District, you may have joined us.
Yes. Yes. Good morning. This is John Rubin with Westlands.
Thank you. Good morning, Mr. Rubin.
Thank you.
And I'll just circle back to North San Joaquin Water Conservation District. Do I have anyone representing that entity, or Ms. Spalletta, have you joined us? All right. That completes my list of the NOIs. Is there anyone else who either filed an NOI or who intends to participate today who has not yet identified themselves? Great. I think we got through that pretty well. I think now I'll move on to the substance. First of all, I'll just note that I did receive a pre-hearing conference statement from San Joaquin County. I appreciate that. Filing a statement was not required, but did any other party submit a statement just to make sure that I have that to my attention? I just, as far as I know from my records, I received a statement from San Joaquin County and no other party. Good, thank you. I'll start off by noting a number of agenda items that I have to give us a sense of where I think we'll go today and the issues. And of course, the last agenda item is always any other procedural issues that any of the parties would like to raise. Also, I think we should think about during this conference today whether or not it would be appropriate or helpful to schedule another follow-on pre-hearing conference as we move closer to the hearing. So keep that in mind, and we'll get to that at the end. Here are the items I have on my agenda. First of all, there's a party status request by Placer County Water Agency and the City of Sacramento. Those entities had not previously appeared in this proceeding, so we can address those. Second, I have the request to postpone the hearing by San Joaquin County. Third, I would like to talk about deadlines for amended NOIs, case in chief evidence, rebuttal evidence, and address the question of whether or not to set a deadline for rebuttal evidence and written rebuttal testimony. Fourth, are time limits for the various phases of the hearing. That would be policy statements, opening statements, summaries of written testimony, and generally a discussion of how the hearing might proceed. Fifth, I'd like to talk about whether or not to set a deadline for written motions in limine or similar motions to exclude evidence. We'll talk about whether or not that would be appropriate. Sixth, I have a deadline for closing briefs. If we would like to have closing briefs, I generally find those to be helpful, so I would like to talk about that. Finally, last on my list are any other procedural issues that we think ought to be addressed today. And my excellent team has notified me that Mrs. Alesi, you may have just joined us, and I wanted to take your appearance and say good morning. Mrs. Alesi, are you with us?
Yes, good morning. I was disconnected and just got back on. Thank you.
Wonderful. And I didn't have Stockton East. Are you here on behalf of Stockton East?
That's correct.
And I didn't have an NOI. That entity is that. Did anything that in our file?
I thought one was filed.
Okay. Let's both check.
But okay, will do. Thank you.
Thank you. So moving on, I believe first is the party status request by Placer County Water Agency and the City of Sacramento. I'd just like to hear a little explanation, partly just to educate me. We'll start with Placer County Water Agency. Mr. Kelly, if you would just briefly summarize the interests of PCWA in this proceeding and why you're seeking party status.
Yes, and Hearing Officer Kunze, I put that briefly in my email that attached my notice of intent to appear.
Yes.
Placer County Water Agency operates the Middle Fork project. It's a hydroelectric project in the American River watershed. Comprises a couple of reservoirs, hydro facilities. It also supplies consumptive water to most of Placer County, most of the residents of Placer County. We also have a contract with the Bureau of Reclamation for 35,000 acre feet from Folsom Reservoir. We are a wholesale provider as well as a retail provider to some agencies both in Sacramento County and Placer County. And we regularly participate in the American River Water Forum and do a lot of work focused on the lower American River, temperature, habitat, and things like that. And so we've got significant interest in what happens in the American River watershed.
Thank you. That's helpful. I'm going to deal with these together because I think we can do it together. So I'm going to move to Mr. Miliband. Would you provide the City of Sacramento's interest? I mean, to some extent, it's self-explanatory, but I was curious whether I noticed that SMUD, at least according to my records, didn't file an NOI. I didn't know if there was a relationship between the City of Sacramento now joining and SMUD's participation, or can you just address that for me, please?
Yeah, and if I may speak for him, Mr. Miliband's not on the call right now.
Oh,
he
thank you.
would be here potentially later, if depending on how late it goes. But there, as far as I know, the City of Sacramento has four water rights permits on the American River in the amounts of close to 325,000 acre feet. And the city would just like to monitor the situation to make sure that its water permits usage isn't being adversely impacted.
Thank you. Based on, from my position, we're early in this proceeding. We're going to get to this next, but I think the hearing is going to be somewhat postponed. I don't see any problem with allowing these two parties to participate in the hearing. I think they both have interests related to the application. But I would like to hear if there are any objections from any of the other parties to allowing Placer County Water Agency and City of Sacramento to participate as parties in this proceeding. So absent any objection, I will grant party status to the two entities. I will add both of you to our service list, and that service list will be circulated with any post-conference. I'm sure there will be one, a post-conference order resulting from this conference. So thank you very much.
Thank you.
Thank you.
Second is the request to postpone the hearing by San Joaquin County. There were two elements to that request as I understood it. One was a postponement for a number of months to flesh out the water availability analysis and respond to some of the responses, if you will. The second request was absent that to postpone the hearing based on a scheduling conflict, which I certainly understand, and that makes sense to me. I will say I don't think that the water availability analysis to me at this point, given the hearing issues, which are fairly limited and really retrospective, I don't think it makes sense to postpone this hearing for 9 months while that is ongoing. The hearing issues here are really whether or not the diligence has been demonstrated to date. On the other hand, I do think it makes sense to postpone the hearing somewhat to deal with the scheduling conflict and also just give us a little more time and breathing room in this proceeding. So I am looking at moving it out about 30 days. So right now we have on the calendar August 30th. I was looking at the week of September, I have in my notes 27th, but I'm not sure that's the first day in the week. Excuse me while I look at my calendar. Yes, so I was looking at starting possibly the week of September 27th through October 1st, that we would choose 3 days within that time frame. But are there any conflicts from any of you, or do you need more time to check with your clients or your potential witnesses as to their availability the week of September 27th? I'll start with San Joaquin County.
Thank you. I still would like to reiterate our request to extend for the water availability analysis. So I just want to still reiterate that request, and the basis is to address one of the hearing issues with regard to discussions with protestants. That was the reason for that extension. Okay. With that comment, I do not have a conflict, but I would need to check with my client and others to determine if there's any conflicts with regard to witnesses.
Okay. I'll move down the list. I think what I'll probably end up doing is we'll leave that open and we'll set a time to get back to the AHO from all of the parties to confirm availability that week. Let's also look at an alternate week. We have some conflicts within our office, which is why I'm looking at another possibility would be the week of September 13th, which would still postpone us by about 2 weeks and move away from that conflict. So I'll ask all of you to consider the week of September 27th and the week of September 13th. Ms. Brenner, do you have any conflicts that you're aware of for the week of September 13th?
No, I do not.
Okay, thank you.
It appears that one of my clients that would be a witness does have a conflict on the 13th, though.
On the 13th, the day or the
week of the 13th?
The week of the 13th.
Yeah, if we go into October versus earlier, that would probably be better.
All right, let's look down the road.
And there's Matt Zadar is on, and he can speak as well as to his availability.
We could do so first possibility is the week of September 27th. The second possibility would be to look at October 4th and 5th. And then we have internal scheduling conflicts the remainder of that week. Oh, I'm sorry. We have not October 4th and 5th. We can look at the week of October 10th. I will note for many of us who practice in the environmental area, it is the Yosemite Environmental Law Conference at the end of that week, but I think we could all get through this hearing in the earlier part of the week. So let's look at September 27th and the week of October, starting October 11th. That's Monday. Ms. Brenner, do you have, does the week of October 11th look plausible to you? Are you going to tell me no?
I have a conflict on the 12th, but I can see if I can get that resolved.
All right. Well, the first line will be September 27th. Then we'll look to the October 11th, and if we need to, if we need to work from there, but hopefully we can all come together. There are many parties, so I ask for all of you. I mean, obviously San Joaquin County, your primary party here, but I ask for all of us to try to work together to schedule some days for this. We can separate them out if we need to. May make sense actually to do cases in chief and then rebuttal a week later. I don't have a problem with that, but let's see what we can do. September 27th, the week of September 27th and the week of October 11th. I hesitate to go through the entire list of 20 parties, but if there's anyone else who is aware of an absolute conflict either of those weeks, would you please speak up now? As I said, I'm going to leave time to check with your clients and your witnesses and get back to me. But if there's a conflict you're aware of, will you please let me know now?
Good morning, Madam Hearing Officer. Chris Schutz, California Sport Fishing. I have a conflict on the 27th only.
Okay. Thank you, Mr. Schutz. So we'll look in that week, and please remind me when I ask for folks to get back to me with availability, please in writing, please remind me of that. But that is helpful. We won't schedule for the 27th, but we may look at the 28th, 29th, and the 30th, or October 1st. So I'll set a deadline. If you would please, all of you get back to me by the end of this week, which, flip through my calendar, excuse me. By the end of the day on Friday, July 16th. And please just email the administrative hearing office with your availability or lack of availability the week of September 27th and the week of October 11th. And I will use those to coordinate some hearing dates. I will also use those to set deadlines. We'll talk more about deadlines and appropriate deadlines, but I'll back them out based on how far we postpone the hearing.
Madam Hearing Officer,
yes,
would it facilitate things if we only provided the dates that we are not able to?
Yes, that
yeah.
would be, thank you.
Because I mean, I can tell you right now, we will go ahead and make ourselves available. Someone from our firm can cover this on whatever date you choose. So we're not going to be concerned about the dates.
Thank you. Yes. So if all the parties, that is fine. If you have any conflicts either of those weeks, please let me know in writing. If you don't have any conflicts, you are welcome to not file anything with the office. Thank you. Thank you for that clarification.
Madam Hearing Officer, can I ask, do you anticipate this being a remote or an in-person? Because that affects my availability the week of the 11th.
Absolutely. The intent now is to have this remotely. I don't think at this point we're not scheduling any hearings in person yet. So this will be a remote hearing.
Thank you.
For the question. Are there any other comments with regard to the postponement of the hearing, the dates of the hearing, or the number of days we schedule for the hearing? Third on my list are deadlines. We won't be setting precise deadlines because we haven't set the hearing dates. I generally will back those out. But I do want to talk about one, amended NOIs. I believe, Ms. Brenner, you raised that in your pre-hearing conference statement that the county may want to amend their NOI and other parties may want to as well. And I think that's fine. So what I would intend to do is set a deadline for amended NOIs if there are changes in witnesses, that type of thing, and so that we're all aware of who those witnesses are. But that would be sometime before the deadline for submitting evidence for cases in chief, maybe approximately 2 or 3 weeks before, but I will set a deadline for that. Ms. Brenner, do you have any other comments about an amended NOI deadline?
No, that's fine. Just
Thank you.
the ability to do it and prior to testimony being submitted is exactly, yeah, it's exactly right.
Good, thank you. I will do that. Second, I wanted to talk about whether we want a deadline for rebuttal evidence, including rebuttal testimony in writing. I think this facilitates hearings. We don't always do it, but it facilitates hearings and is generally helpful. So I would like to set that, but I wanted to hear from all of you whether there are any concerns about setting a deadline. If we did set a deadline, I'd anticipate setting the deadline for rebuttal evidence to be approximately 30 days after the deadline for case in chief submittal, so that there's time to respond to that. Ms. Brenner, do you want to start us off? Do you have any comments or concerns about setting a deadline for submission of rebuttal evidence, including written rebuttal testimony?
No, I don't have any concerns with that. I'd like to be able to do that in case it's needed, but I don't have any concerns with it.
Good, thank you. Is there any other party who would like to comment on rebuttal evidence or setting a deadline for rebuttal evidence or rebuttal testimony? All right, we're moving right along. Next on my list, I have a discussion about time limits. I believe the hearing notice already set a time limit for policy statements of 5 minutes. I will allow opening statements as well if parties would like to provide an opening statement. It's not required, but I was thinking of setting a limit on opening statements of 5 minutes as well. I also reviewed the NOIs with the time estimates for summarizing the written testimony of each witness. I thought the requests in the NOIs seemed reasonable, so I appreciate that. I will allow all of the parties the amount of time requested in the NOIs. I think that seemed appropriate, and I think it seemed fairly streamlined. I ask all of the parties to streamline your presentations of your witnesses as much as possible. I will read the written testimony in advance of the hearing. So I will generally be familiar and have read all of the written testimony. So the summary really is a summary to highlight any of the points that I think are of particular importance that you want to bring to my attention, or particularly technical or complex that you think it might be helpful for me to go through more slowly or a second time. I did notice that Mr. Gorig, and please correct me if I'm pronouncing his name incorrectly, is a very popular witness, and that's great. I think he was identified by 7 different parties. I assume, and I guess I would say I assume and I suggest that the parties work together to submit his written testimony as a single exhibit. And I see a nod from Ms. Buckman, thank you. And that his testimony would be presented all at once during the hearing, and he would be and cross-examined at that time, all in one presentation. And I just wanted to pause there. Maybe I'll turn to Ms. Buckman, but I know many parties identified him. Is that the intent of the parties to present?
Yes, that is correct. And that is how his testimony was presented in the water fix hearing. So same type of idea there.
Wonderful. Thank you very much. I appreciate your coordination. That is really, really helpful. I also just wanted to mention for any of the other witnesses, it looked like the witnesses were fairly individual, but if any party thinks it makes sense for their witnesses to be cross-examined as a panel, particularly if the testimony is really closely related, please just keep that in mind and bring it to my attention either at the next pre-hearing conference if we have one, or during the hearing. Sometimes the panel cross-examination is helpful, sometimes it's not, and I think we can deal with it somewhat on the fly, but just keep that in mind. So I went through a lot there. Are there any comments on time limits or any other element of the presentation of witnesses or opening statements or policy statements that any of you would like to address at this time? Great. Moving on, I have next on my agenda whether or not we need a deadline or would like to have a deadline for written motions in limine or similar motions to exclude evidence. I don't know the extent to which there may be motion practice on that issue, but it is helpful for me to have those in advance in writing so that we can deal with them before the hearing. So what I'm thinking is if we set a deadline, it would not be the exclusive opportunity to object to evidence. You could certainly raise objections orally during the hearing, but if you would like to submit a written motion in advance of the hearing so it can be dealt with in advance of the hearing, I'd like to set deadlines for those. And I think it's been helpful in other hearings to do that. What I was thinking in terms of deadlines would be a deadline of about 2 weeks after the deadline for case in chief submittals. So, and as I said, this wouldn't be the exclusive opportunity. You would have an opportunity to object at the hearing, but this would be the opportunity to submit those objections in writing. And then I would allow for written responses to that the following week. So allowing about a week after that to respond in writing. And I think if I set those deadlines appropriately, I would be able to get a ruling out in advance of the hearing so that if there were objections that may affect the appearance of witnesses or the way you're presenting evidence, we would all know that before the hearing begins. Do any of the parties have any comments or concerns or objections to that approach?
I assume that case in chief testimony would be 30 days before the hearing, and then this would be 2 weeks. So we have a 30-day, 2-week, 1 week kind of schedule. Is that what you're talking about?
Yes, the case in chief deadline would be at least at least 30 days, if not, I think a little bit more, maybe 6 weeks, depending on how we schedule it out.
If you schedule, what would be helpful is if we could do the objections 2 weeks prior to the hearing date, and then respond to those objections a week before the hearing.
Yes.
Just focus more on hearing
The hearing
testimony versus evidentiary objections.
Yes, I agree with that. And that would give me a week to issue a ruling on those.
Right.
That makes sense to me. Thank you, Ms. Brenner.
Thanks.
Do any other parties have comments on that?
Ms. Kinsey, Kevin O'Brien for El Dorado County Water Agency. This is probably more of just a general comment. I know from recent experience with the AHO that you are quite conscientious about holding the parties to the scope of the hearing as identified in the notice. And I guess I just want to make the comment so that we can avoid lengthy motions in limine, that I think it would be very helpful if all parties could focus their cases on those 4 issues. Obviously, there's a lot that you could talk about with respect to the American River, but I think it's important in this phase of the hearing to focus on the issues teed up in the hearing notice. So I just wanted to make that comment.
Thank you, Mr. O'Brien. That's probably a good public service announcement. Thank you, and that is true. I will reiterate that Mr. O'Brien had the, I don't know, I won't say an unfortunate experience, but had the experience of appearing before me in the recent Kings River hearing, and there the scope of the hearing was a significant issue and did affect the witnesses that I ultimately allowed to present evidence during the hearing. I do intend to be similarly careful about limiting the evidence presented to the scope of the hearing and the hearing issues identified in the hearing notice. I have reviewed your NOIs. I do have some concerns that some of the testimony may go beyond the scope of the hearing issues particularly, but I'm waiting to see how that plays out because I don't know what the testimony is at this point, and we'll see when that testimony comes in. But it would be helpful for all of the parties if you do have plan to raise objections about whether or not certain witness testimony is within the scope of the hearing issues. It's very helpful to raise those in writing in advance, and then also to each of the parties to consider whether or not your proposed evidence is related to the hearing issues, which here is rather narrow. We're not considering the application as a whole at this point. It's a more limited issue with respect to whether or not due diligence has been demonstrated to date. So thank you, Mr. O'Brien. And it's a good comment for all of the parties so that we can avoid as you noted, a lot of motion practice on this issue. Are there any other comments on the issue of motions to exclude evidence and deadlines for those?
Yeah, Ms. Kinsey, if you don't mind, I'd like to raise a question that's related to Brian's comment and the hearing issues. And, Mr. Goring has been listed as a witness for a number of American River parties with the thought that he could provide some testimony related to the water availability analysis. But we did want to ask a question about your expectation with respect to testimony on the water availability analysis at this point in the proceeding, in this phase of the proceeding. And just kind of clarify what your expectation is with respect to testimony on, I guess it's 1A, which deals with information related to the water availability analysis.
So it's a good question, and I'll do my best to answer this on the fly. But my sense at this point is, and based on my understanding of the issues and where we are, is that the water availability is relevant at this point in the proceeding with respect to demonstrating diligence or lack of diligence by the applicant, and the extent to which the applicant has been working with parties or not to resolve the issues related to water availability. At this point, we're not addressing the issue of whether or not water is actually available to serve the applicant, because we're not at that point in the processing of the application. That said, I mean, this is going to be a judgment call on your part and the party's part. There are other elements in the hearing as to whether or not the applicant's proposal to divert and use water has any basis, is reasonable to some extent, and has any basis and is feasible, at least as a prima facie matter. That's one way to articulate that. So that is not a particularly elegant way of answering your question, but I think the answer is generally, you may have to make that judgment call, but I don't think the broader issue of water availability for purposes of processing the application and moving forward and deciding whether or not water is available for this application and in the amounts requested, I don't think that issue is before us at this point.
Okay, that's helpful. Thank you.
I hope it's somewhat helpful.
It is. No, my understanding from what you're saying is that the issue of water availability as a substantial matter would potentially come up at a later stage of the hearing if this goes to the application phase.
Yes, if we move forward and if the application moves forward and is not canceled and is not denied, if the outcome of this hearing, I think the other option of the outcome of this hearing is maybe to set a time schedule for the applicant to complete certain milestones. And essentially this would move the application back into the processing stage, whether it's by the division or whether it's before the AHO. That would be to be determined, but that element of the water availability for the application would come in a later phase in the processing of the application.
Thank you.
Thank you for the question.
This is Ron Stork. I guess I have a similar question on the scope of the hearing.
Yes, please, Mr. Stork.
You've outlined two questions and as the purpose of the hearing, and established some questions that the hearing is intended to answer. With regard to the water right application, diligence, and potential time schedules for if it's not canceled. But you also note in the hearing notice that the county intends to further investigate the feasibility of using the head of Folsom South Canal at Lake Natoma as an alternative point of diversion. That is not in the water right application. So the question is any testimony with regard to a potential amendment or new water right application or revised water right application with regard to a new point of diversion, in order would be seen as helpful to the hearing officer?
Thank you for that question, Mr. Stork. I believe the note you identify in the hearing notice with respect to the statement that the county may be considering alternate points of diversion. I believe that was raised during I recall that was raised during the status conference initially, which is why I reflected that in the hearing notice to explain the basis for setting a hearing on the issue of the diligence of the applicant with respect to the application. I thought that information was relevant because it shows that there may be open questions about the nature of the project and the likelihood that the project will go forward. And that was one of the considerations in setting this application for a hearing on the issue of whether or not the application should be canceled or whether some kind of time schedule order should be put in place. So I see the relevance of these alternate points of diversion. As you note, they're not currently part of the application. It's not an element of the application. I think it's relevant not as a matter of, at least in my perspective, relevant not as a matter of information about this application, but it is relevant to show whether or not the county has a concrete project that they're prepared to move forward with and intend to move forward with. I don't know the extent to which the county obviously plans to put on evidence with respect to these alternatives. That may be something that becomes more clear in their case in chief evidence. So once again, I think it may be a judgment call based on what information the county intends to present about its diligence in pursuing this application and its ability to continue to pursue this application. Does that help to some extent? So we're not getting to the substance of the issue of whether or not those alternate points of diversions would work or would make sense or that type of thing. But I do think it's relevant to consider where the county is in terms of pursuing this project, that it may be that the county has not yet identified the points of diversion that it ultimately intends to carry out with respect to the application.
The reason why I brought that up is that Friends River intended, at least on the basis of an abundance of caution, to present some witness testimony about the nature and the history of diversion proposals from that point of diversion. And so I guess you haven't exactly answered the question on whether or not that should go forward or not.
Well, let me answer it this way, and I should clarify, my responses today certainly don't preclude future motions or objections by other parties with respect to evidence. I don't intend to make evidentiary rulings today based on this information, but to give you a sense of where I'm coming from and what I think. Given the long history of this application, I think the history is helpful for me to understand. It's helpful to understand why we are where we are. I think the county in the status conference presented information about why we are where we are and the development here. So my initial response would be that information about the Folsom South Canal or related history in the development of this application and the points of diversion and the sources of water, I think would be likely helpful to me. That statement made, I don't want to preclude parties objecting to evidence as appropriate. I will consider those arguments, but at this point in time, I think that information would likely be helpful for me to help understand the issues presented in the hearing. Is that a more direct response?
Yes, it's more helpful.
Okay, thank you. And I'll give a chance for other parties to respond, but I did want to circle back, Ms. Brenner. I know I've said a lot of things and I don't know if that raised any questions for the county with respect to the issue of evidence, the scope of the hearing, and those matters.
I have no comments based on the conversation today.
Thank you. Are there any other questions or comments from the parties on the issue? I think we're now on a somewhat separate issue of the scope of the hearing and the scope of the issues and the scope of evidence to be presented. Finally, on my list, I have setting a deadline for closing briefs. I don't believe I did that in the hearing notice. I've found written closing briefs to be helpful, I think more helpful than oral closing arguments. So I would like to set a deadline for written closing briefs. I was considering doing that, setting the deadline to be about 2 weeks after the close of the hearing. But I wanted to hear if you had any concerns or would like that, if you think that's an appropriate time period. Ms. Brenner, do you have any comments on that?
I would just comment, 4 weeks would be a little more helpful.
4 weeks.
Yeah, that would be
Probably
helpful,
do that, yeah.
especially during the time period that you're talking.
It's busy.
It's gotten really busy with the lifting of the COVID rules. It's a little out of control.
Yes, and there's some of us like me who have school-age children, and it's a busy time too. Fall is busy. Okay, 4 weeks, that seems fine to me. Are there any other comments from any of the parties about closing briefs or a deadline for closing briefs? Are there any other procedural issues that any party would like to raise at this point? I've exhausted my list of agenda items.
I just want to be clear, we're changing the deadlines for submittal of testimony based on the change of the hearing date, right?
Yes, thank you for that clarification, that those dates will be changed. Once we settle on the hearing dates, I will change those deadlines approximately in accordance with how long we postpone the hearing.
Right, they'll just track based on the new date.
Yes, because we now will have a deadline for submittal of rebuttal evidence, that may affect by a week or two.
Okay.
But I intend to set, I think, the deadline for submitting rebuttal evidence and testimony fairly shortly before the hearing, so that it won't, the relative change and will track. So the case, if we move the hearing out about 30 days, the case in chief deadline will move out about 30 days.
Okay, thank you.
And if I shouldn't add, if this hearing notice goes out and there are significant concerns with the deadlines, you certainly may submit in writing a request to amend those deadlines. My final question is whether or not we need another pre-hearing conference. I think we've covered a lot of territory, and it may be another option is if issues come up and any of the parties think that a pre-hearing conference would be helpful, you can submit a request and we can schedule that. But at this time, I'll start with you, Ms. Brenner, and then ask the remaining parties. Do you think we should schedule at this time another pre-hearing conference, or are we ready to move forward with this hearing? Obviously, we need to schedule the dates to do that. But do you see a need for another pre-hearing conference before the hearing?
You know, it may be helpful after the submittal of evidence to have a pre-hearing conference, just, a week, set it maybe a week ahead of time, just so that we're right out of the gate, ready to go on the hearing.
Yeah.
And if it's deemed not necessary, we can always cancel it. But just based on, just sometimes it's helpful.
Yes. Do you think it should be scheduled? I think after the submission of cases in chief, that makes sense. Do you think there's any relevance to whether or not we schedule it before or after the deadline for the motions to exclude evidence?
I would schedule it after all.
After all that, okay.
Yeah.
So pretty close to the hearing.
Correct. That would be my preference anyway.
That makes sense to me. I think I'll hear from the other parties in a moment, but what I would do is schedule it once we settle on hearing dates. I would put all of these dates out in an order, and then if there are conflicts or concerns, I would take requests in writing to change the date if there's a conflict. But I would set it based on when we end up setting the hearing. Do you have any additional comments, Ms. Brenner?
No, I don't have anything further. Thank you.
Thank you. Any of the other parties have any comments about a pre-hearing conference or the timing of that? Or any other issues? I think we're nearing the end of our pre-hearing conference. So if there are any other issues, this is a good time to raise it. All right, just to summarize then, please, if you have conflicts of the week of September 27th or October 11th, please alert the AHO by sending an email to the AHO identifying the conflicting dates by this Friday, which is July 16th, by the end of the day. I would appreciate that. And then after those are received, I will be issuing a conference order that will, and a amended hearing notice that will identify new hearing dates. We will identify all of the deadlines for amended NOIs, case in chief evidence, written rebuttal evidence, including written rebuttal testimony, as well as a deadline for motions in limine or other motions to exclude evidence, a deadline for the submittal of closing briefs after the hearing. And then we'll also include a date for an additional pre-hearing conference pretty shortly before the hearing. Are there any comments on that summary? Otherwise, I'm prepared to adjourn this pre-hearing conference this morning. Well, thank you to all of you. There's so many of us. Thank you for making this a smooth process and moving through this quickly. I really appreciate it. I think we got a lot done today. So thank you very much. And this pre-hearing conference is adjourned, and I will see you down the road this fall.
Thank you.
Thank you.
Thank you.